It's been almost 2 decades since we started our journey to educate and help you take action so you may better manage your financial future. Our goal is to help you accomplish your life's purpose. This podcast reveals financial tips, strategies, and insights that will help you to set your financial goals and guide you along the way. This is Managing Your Financial Future, brought to you by the advisors at Lucia Capital Group. We welcome you back to Managing Your Financial Future. Johnny Dean here, your podcast host, congenial podcast host, along with our congenial guest here, Professor Rick Plum. I'm going to venture a guess that nobody's called you congenial in months.
Or ever?
Or maybe ever. I don't know.
Not that I know of.
No. Professor Plum, certified financial planner, professional. Johnny Dean, podcast host. I'm not an advisor. I should remind people of that. But I host this podcast, and we try to get as much information to you folks as possible. And some of the topics we talk about might seem a little bit complex, but we do choose these from what people are talking about. Professor, whether
asking
it's
about
clients, people asking about this, we sometimes, depending on what time of year it is, we'll talk about taxes one time, maybe we'll talk about planning, we'll talk about
required minimum distributions towards the end of the year because you got to get them done.
Yes, as a matter of fact. And then when the new year starts here, we're going to give you some topics, things that you need to think about early in the year. Always a good time to not just make New Year's resolutions, but to also resolve to get things done. Whether it gets done or not, I don't know. But now here's something, a topic that, we've talked about required minimum distributions and things like that in the past. We mentioned it last week somewhat in passing on our last show. Required minimum distributions, when you are, for people who are inheriting something, there's a large transfer of wealth they've been talking about going on now as the baby boomers start to retire and die.
Seems to have missed me, but okay.
Well, okay. It doesn't hit everybody. It's like a rain cloud. Some people get less than others. Some people get drenched. But as this kind of continues and we see a transfer of assets from one generation to another, there are certain things that people need to know, Professor Plum, that can affect them from a financial standpoint and affect them from a tax standpoint. And I want to talk a little bit about what you need to know about inheriting, we'll call it an IRA. I mean, there are other things you can inherit, 401ks and things like that.
Right, retirement plan. So I can't just say any tax-deferred account because annuities are tax-deferred accounts, but annuities can either be held personally as what they call non-qualified, or they can be held inside of an IRA or a 401k. They're an investment more than anything else at this point. So we're going to talk about the required minimum distributions on retirement accounts, 401ks, 403bs, IRAs, Roth IRAs, and Roth 401ks, or some of the 457s, basically retirement plans. Yeah,
retirement plans, and more specifically about when you inherit a plan. I think many people know, I would assume most people who at least listen to our podcast know, that if you're an owner of an IRA or a 401k or anything like that, at age 72, you as the owner are going to have a required minimum distribution under current law. That's how that works. But what happens if somebody dies and now I've got the IRA or the 401k or we'll call it retirement plan, and what happens to me tax-wise? What do I have to do? So we're going to talk about that here.
Okay, and realistically, there's basically two classes of beneficiaries. There is a spousal beneficiary, current spousal, and there is a non-spousal beneficiary. Those are the two broad categories. You fall into one or the other. You were either married to the person who died, or you were not. And that's what it is.
That's 100% of the cases right there.
Yes. And on the one where you were not married, the non-spousal beneficiaries, there's two subcategories in that one. And so we'll get into that as we go. But all right. Basically,
let's talk about spouses first. Let's talk about a spousal, because I think that's the most common. And I think for people who are married, I mean, generally one is going to go before the other.
Yes.
So you're going to wind up, if you're married, you'll probably wind up in this particular situation.
Spousal beneficiaries have the most flexibility. The spouse can just choose to roll all the money into their own IRA.
Okay.
If they don't have an IRA, they can open an IRA and move it all into their newly formed account that's their IRA. And from that point forward, it's as if it had been their IRA from day one.
So if my spouse dies, whatever age it happens to be, and I inherit this by this IRA because it was my
this
spouse's
401k, this 403b, whatever
yes.
the case.
We'll say IRA just to keep it simple, but this applies to all of those. I can roll it. One option is I can just treat it as my own. It's now mine.
And just transfer it to your name and it's yours. But because it's yours, now you are subject to all the rules that belong to you. Like if you're not 59 and a half yet and you desire to take some of this money out of that account that you just transferred into your own IRA name, well, you're not 59 and a half. You take money out of your IRA. Doesn't matter where the money came from. It's now your IRA. You take it out, you have a 10% premature distribution penalty unless you qualify for one of the exceptions. Not many people do. So if you are a younger widow or widower, one of the planning things that you have to look at is, will I be needing the money from my late spouse's IRA to live on between now and when I get to 59 and a half? Because if I do need to withdraw some money, maybe there wasn't enough life insurance because we had a big IRA, and so we didn't think we needed as much life insurance, so I don't have enough life insurance to get me through until I'm 59 and a half. If I'm going to need to tap into this IRA, I may not want to put it in my name. So what are my other options? Well, you can treat it as an inherited IRA. Basically, you stay as a beneficiary. It's a beneficiary IRA.
So it's still in the person who died. It's still in their name.
Yeah, it's basically
and
still,
you're just the beneficiary.
John Smith's IRA for the benefit of Jane Smith or whoever spouse. Mm-hmm. And now we have to deal with because it's not in your own name. Death is one of those things that gets you away from the 10% distribution, premature distribution penalty. So withdrawing money at any age from a beneficiary IRA avoids the penalty. Now that spouse beneficiary can access the money whenever they want to.
So if I'm 55 and my spouse passes
45,
away, 45,
35,
25, you probably don't have a huge IRA, but yeah, I can access that money if I want to.
Still taxable,
yes,
but not a penalty.
Yeah.
And one of the things that a lot of people don't realize is that when that spouse gets out to be 59 and a half or later, now they can roll it into their name as it's their own IRA.
So if I inherited this as a spouse at age 50, I left it in my deceased spouse's name, I hit age 59 and a half, now I can roll it to my name and I still don't have a penalty.
Now, the only thing you have to look at, though, is that the required minimum distributions for that beneficiary IRA, where it's a spousal beneficiary, it does have a required minimum distribution when the original owner would have been required minimum distribution age. Now, I've run into this from time to time where we have a fairly large disparity in age. Mm-hmm. This is back when it was 70 and a half, but maybe somebody was 71 years old and they were married to a 45-year-old. It happens. Or even a 55-year-old. And so we had to look at it. If you leave it in the beneficiary's name, or as a decedent's name, you have a required minimum distribution, because they were 70 and a half at that time, now 72. So we have to treat it as if they're still alive from our RMD standpoint. Mm-hmm. If you roll it into your own name, you don't have a required minimum distribution because you're only 45, 53, whatever the number is. And so we had to look at...
But you can't access
it without a penalty.
Yeah.
So we had to see which one of those was more beneficial, which avenue, which one was more detrimental, and we made our decisions and went from there from a planning standpoint.
So if I inherit an IRA as a spouse, or even as a non-spouse, which we'll get into, I guess, but let's say if I inherited as a spouse, and neither one of us was close to our, they're in their early 60s, let's say.
Well, early 60s is easy because now we don't have a 59 and a half age penalty, and we don't have to worry about RMDs.
But there is no RMD on either side.
No, there's no RMD, and there's also no penalty. So
the penalty goes away.
And so it's just easier to put it all in the surviving spouse's name.
But required minimum distributions for spousal beneficiaries are really dependent upon the age 72
now. And so it's unusual that we run into the required minimum distribution if we leave it in a beneficiary's name.
So as you said, you do have flexibility.
You have a lot of flexibility.
As a spousal inheritor of an IRA.
As a spousal inheritor, you've got lots of flexibility.
Let's talk then about a non-spouse. Let's say you inherit it from Uncle Charlie or whoever.
Or a previous spouse.
Or a previous spouse.
Previous spouses are not considered spouses anymore.
No, you are now a non-spouse beneficiary.
But I have seen it where people will leave it to their previous spouse because they just didn't want to be married, but they get along fine now that they're not married.
That's good.
And maybe they're the mother, father of the children, whatever the case may be. But I've seen it where they leave it to the previous spouse.
I think it'd hold it over their heads as a,
in the cases that I've thought of, that wasn't the issue, but they were actually fairly nice. But
okay, that's
but
good.
A non-current spouse at death, the beneficiary has a different set of rules. And the first thing you have to look at is, when did the person die?
So if I inherit an IRA, I'm going to just say IRA again. If I inherit an IRA from somebody and it's not my spouse, and I'm 55, let's say, years old, first thing I want to know is,
when did the person die?
When did the person die? And that's important at the moment.
Right. I mean, obviously, the further we go, the more likely the event will have occurred in 2020 or later.
But so right now, as we're speaking in late 2021, we need to know when the person died. Why is that?
If the person passed away prior to 2020, there's a different set of required minimum distribution rules than there are for most people that died in 2020 or later. So if the person that you inherited the IRA from died in 2020 or later, it's a much more restrictive distribution penalty or distribution requirement. So let's take the other one first. Somebody died you inherited an IRA from somebody who died in 2019. Now you will have already hopefully set all this up, but maybe you didn't. Maybe somebody died in 2019. 2020, the CARES Act waived all required minimum distributions, so you may not even be paying attention to it yet.
So this could happen.
So in 2019, Dad, Uncle Joe, whoever it was, passed away, and you're the direct beneficiary of the IRA.
Mm-hmm.
You cannot do a rollover. You cannot do a conversion of it. You can transfer it from one custodian to another, and you're going to change the name from the individual to a beneficiary IRA with you as the beneficiary.
That has to happen?
It's going to happen because otherwise you don't have any control over it.
Okay, all right.
Now, you have two options. Now, was the person who died age 72 or older? If they were not, you have two sets of rules to fly by. One is, as long as you start taking required minimum distributions in the year following the year of death. Now, if the year of death was 2019, 2020 was waived, so we would have to do a required minimum distribution this year.
Yep.
If they died before 2019, you would have had to set up the distributions starting in 2019, and you could have waived it in 2020. But if you do that, you can stretch it, and that's where the term stretch IRA came from, over your life expectancy, or at least what the IRS says your life expectancy is.
Right. So if I'm 50 and I inherit this from Uncle Charlie or whatever, my life expectancy for the IRS might be 78.
Well, it says 34.2 years. So your life expectancy would be 84 in that respect. Right. So you set it up, and over that 34-year period of time, you're going to distribute all of the money. But you can stretch it out over those 34 years. So the first year, it's only about a 3.5% required distribution. Then it gets a little bit more each year. But you can stretch it. You can stretch it for the whole 34 years. Now, if you make it to 90, it still had to come out by the end of the 35th year. So it's just... you have a long time. Now, that's the required minimum. You can always take more.
I could take the whole thing if I wanted.
Or you can split it. They only care about the minimum amount that you take. Yeah. And if you start died before 2020, you have that stretch option. Now, if the person was not at required minimum distribution age when they died, then if you missed the first required minimum distribution, the year after year of death, you've only got a 5-year clock.
So I have to take, in other words, in that case, I've got to take all the money out of that IRA
by the end of the 5th year
and pay taxes on it.
Right. This is all about tax planning.
Yeah.
It's not about spending because we'll spend it as soon as we can get it, other than the fact that it might cost us too much in getting taxes. But people talk about the 5-year rule. That was only available if the owner of it died before they got to required minimum distribution age. Other than that, if the person died before 2019 and they were at required minimum distribution age, then you have a required minimum distribution the very next year, with the exception of 2020 because they waived it. So there's a little bit of complexity in there as far as what's going on. You just have to know when they died and when did you start taking your required minimum distributions. Now, I have heard, and I saw this through somebody else, the people didn't know the person died. Or actually, they knew the person died. They didn't know they were a beneficiary.
And they didn't find out until...
The person died in 2018.
Yeah.
And they didn't even know they were a beneficiary until 2020. So they, by definition, they missed 2019.
Yeah.
What we have found is the IRS is fairly lenient on that type of an issue if you can prove you didn't know.
Okay.
And they were going to let them stretch that one.
How often do you see somebody, honestly, how often do you see somebody stretch out? I mean, when they inherit an IRA.
Less than half the time.
Yeah. I mean, I would think, just human nature being what it is, they say, look, I just inherited, look, there's a $300,000 account there, pre-tax account that I just inherited, or whatever the amount is. And you say, well, I mean, why don't I just take it all? I mean, yeah, I'll pay some taxes and
I've
probably
seen people
more.
do take it all. I've seen people say, I want to take it all as much as I can in any given year up to my tax bracket, but I'm not going to wait 34 years like the stretch option. But we do have, I know several people who are stretching out and just taking the required minimum distribution as an inherited IRA. At least for now,
maybe for people
they're still working. They're looking at it that they don't need the money right now, so they've stretched it. And when they retire, they're going to then, let's say they retire at 65. The person died when you were 55. So instead of stretching it out over 34 years, they stretch it
while
for the
they're
first
working.
10 while they're working. Take just the minimum amount so they don't pay too much taxes.
Okay.
And then they're going to use it as what we call bucket number 1 from 65 till 70 when they turn their Social Security on.
That's not bad. That's planning.
That's called planning, yeah.
That's planning. That's exactly what that is. Okay, so that's if I inherit an IRA, I'm a non-spouse, and the person died in 2019 or before.
And we're talking about IRAs, 401ks, 403bs, and Roth IRAs.
Because you've got a required
Roth
minimum distribution.
IRAs do not have a required minimum distribution for the owner.
Yeah.
But for a beneficiary, a non-spouse beneficiary, they have required minimum distributions. And so
they're not taxable to you, but they come out of the Roth.
As long as it's been 5 years.
Well, that's that other thing too. But yes, as long as you follow the rules, they're not taxable. The only thing is they're not under the Roth umbrella anymore.
Well, they're still Roths, but they're still tax-free coming out if they got the qualified distributions. But you do have an RMD. That's the big issue.
Well, that's just I'm saying. But if you say, well,
Once you
heck,
take the money out.
I'll take the entire sum out and not pay taxes on it, but then it's not in the Roth anymore.
Right. Then you don't have the tax-free growth of it.
Right. So okay.
So now that was for people who died in 2019 or before.
Let's talk about you inherit an IRA as a non-spouse from somebody who died in 2020 or later.
So 20 or later, most of it's fairly straightforward. Now we're talking about non-spousal beneficiaries. If whoever you inherited the retirement account from in 2020 or later, you have 10 years for the most part. It doesn't matter what you do in years 1 through 9. As long as you can take any amount you want out or none out.
Or none.
From years 1 through 9. But in year 10, whatever is left in there, could be all of it, could be only part of it, has got to come out. Otherwise, you've got a required minimum distribution of 100% in the 11th year and a penalty.
If you don't take it, the penalty is, what is it, 50%?
Still 50% of what the shortfall is. So if I had 100,000 in there and in the 10th year I did not take it, my penalty's $50,000.
Wow. You lose half the IRA right there.
You're going to lose more than half
because you're going to pay taxes on that
money. You're going
money.
to pay taxes too.
Oh, man. Yeah, so don't do that.
So now that 10-year rule applies to all non-spousal beneficiaries. Sounds simple, right? Well, I shouldn't say it that way. It applies to most non-spousal beneficiaries. Children under the age of 18 who are beneficiaries, the 10-year clock does not start. They use the old stretch rules until they turn age 18. Then they've got a 10-year rule.
Okay.
Beneficiaries that are less than 10 years or less younger than the person that died still have the old rules and they can stretch it. Beneficiaries who are chronically ill or disabled, as defined by the Congress, can stretch it.
It's 10 years or less younger. So if I inherit it, if my Uncle Charlie is only 6 years older than me.
Well, like if my brother passed away or I passed away,
okay, that's true.
If I were single and I left it to my brother or vice versa, we're within 10 years of each other.
So then
I could stretch that.
You can stretch that. You don't have to take it out within the 10 years.
Yeah.
But as you said, more than half of the people who inherit it at any...
Well, it has a lot to do with where they are in their life. I know the people that are stretching it and inherited IRAs are people that are retired and have enough money on their own and they don't need this extra money. And so it's not a burden, but it's another taxable event. And
sometimes they're in their 20s and they inherit these IRAs, and they want it now.
Well, yeah, that's what I'm saying. Where are you in your financial life? The younger you are, the more likely you're going to take it a little quicker.
Yeah, I can imagine somebody who inherits a big IRA for whatever stupid reason at age 16, and then at age 18, they say, now you have to take this out in 10 years. Kids can say, I'm going to take this out in about 10 minutes. You know, I mean, that's just the way it is, right?
Right. And so it depends on the individual, how savvy they are, how financially astute they are, what their current financial situation, what their current tax situation is. And also, a lot of that distribution of 100% of the inherited money has to do with how much. When it's $25,000, $30,000, $40,000, I would say the majority of those are cashed out within a few minutes.
Easily.
When it's $400,000, $500,000, $1 million, those get spread. Whether they're spread out over 10 years, whether they're stretched over the life expectancy, maybe not, but they're not taken in lump sum.
Just because of the taxes that have to be paid.
Exactly.
Yeah.
And so it's all about where you are in your financial life as the inheritor, and what's going to be worth to you. And like I said, if it's $10,000, I don't know anybody who stretches a $10,000 inherited IRA.
Wouldn't make sense.
I don't know anybody who's going to spend the 10 years, take $1,000 a year out of it. They're just
$1,000 a year. That's like $90 a month or something.
83.33
a month. I mean, come on.
They're just going to take the 10. But if it's $1 million IRA, they're going to take it. They should start taking it over the 10 years rather than waiting until the 10th year and taking out $1 million plus growth.
Well, you'll wind up, because now you'll
pay less cumulatively over the 10-year distributions than you will on the 1-year distribution.
Yeah, I mean, $1 million. All of a sudden, you got $1 million more of income for that year, plus whatever you were making.
Yeah,
that tends to add up. In fact,
that's where you find the bracket creep.
Boy, isn't it though? I mean, you're already
just blew
in
the brackets away.
You're in the top. You're in the top bracket for most of it,
and for most states. I mean, if you're in a state, don't forget
true.
states. States got taxes too.
States have taxes too.
Not all of them.
No, there are what, 8 or 9 that don't.
I don't know the number.
It's not that many.
It's a minority of states.
Chances are, if you're listening to this, you're probably going to have some form of state tax as well. So the point here is that you gotta, if you're inheriting an IRA or a 401k, any type of retirement plan. And I guess that's a retirement plan where there may be a required minimum distribution for that, a pre-tax type thing.
Well, I can't think of a retirement plan that doesn't have a required minimum distribution for the beneficiary or for the owner, for that matter. At some point, there are different rules, but there's rules.
Well, the Roth, I guess, but some people don't know. If you inherit a Roth, as you said, you're going to have a required minimum distribution
for inherited accounts. I can't think of one that doesn't have a required minimum distribution of at least retirement accounts.
If you're going to leave an account to somebody, is it better to leave, say, a 401k or IRA? If you want to plan, let's say you don't need the money in these IRAs or the 401ks or whatever you have, or maybe you have an annuity, and we don't talk about those a lot, but you have those. What's better to leave to somebody to inherit?
What's better? The Roth, obviously, it's tax-free.
Roth would be, sure.
Personal money currently is better than it. We have a client that had a fairly large personal portfolio, large IRA portfolio, and has been doing conversions and has a reasonable sized Roth portfolio. Yeah. They have a very nice portfolio. It's more than $1 million. Let's just say that.
All right.
It's probably closer to the 10 side. And they were also very charitably inclined. And so what they're doing is they're taking just the RMDs from their IRAs, and they've made the charities the beneficiary of their IRAs. And it just happens that the numbers work out fairly well. They're going to give a little bit more to the charities than just the IRAs. But the charities are going to inherit the IRAs, not the kids. Now, they were going to split the estate between the kids and the charities anyway. But this way, the kids inherit the Roths, no tax, the personal money, currently no tax, instead of the IRAs. And the charity inherits the IRA. And how much tax is that charity going to pay on that IRA?
Well, they're not going to pay any taxes because it's a charity.
So it works out really well for them.
We've talked about this in the past about as part of estate planning and some of the things that are better for somebody to inherit. If you are charitably inclined, it makes more sense for you if you have pre-tax accounts. In many cases, Professor Plum, you're saying
leftover go to charity.
Give the charity the pre-tax accounts, and give the personal or Roth or whatever
to the kids,
to the
heirs,
or whoever you're giving it to.
Now, where we see problems are where we want to leave a chunk of money from the IRA, because that's what we have mostly, I mean, to a specific heir, but that heir can't handle money. That heir is just dangerous with money. You leave them, $100,000, $200,000, $300,000, it'll be gone.
It'll be gone quickly.
And it won't be gone in a good way.
No.
And they may be detrimental to themselves with that kind of money.
Sure. They may not live to see the entire sum spent either. Right?
It happens. Yeah. And so you want to put controls on it. And so that's where you have to do some coordination with your estate planning, your trust work. Normally, I don't personally like seeing the trust involved if the beneficiary is a person that can handle the money. But if the beneficiary can't handle the money, then you're probably going to want to have a trust and a trustee other than that person controlling the money and making distributions as necessary, as required to that individual, rather than just letting the individual have total carte blanche access to the money.
Again, this is why you use an advisor you should use an advisor to help you out. Somebody who knows what's going on, somebody who knows, well, if you do this, here's what will happen, here's what can happen. Somebody who has perhaps seen the good and the bad of that. And if you want to get in touch with Professor Rick Plum or any of the Lucia Capital Group advisors, talk to them about things like this. Do you need the money now? Are you saving this for your kids? What happens if you do inherit an IRA? What do I do with this money so that I'm not overly taxed, and at the same time, it's not going to be a tax burden on somebody else? There are both sides of this. 800-644-1150, the number at Lucia Capital Group, 800-644-1150. They can talk to you about things like this. Now, you guys don't actually set up estate plans.
We're not lawyers. We can't do the legal work. We can help you understand some of the concepts and things of that nature. We can help you understand beneficiary assignments and other things. We cannot do the physical, actual estate work.
No, but a lawyer will take instructions, and that's what they do when they set this up. It's important. You can take these, whatever strategy or plan that you've given these people, and you can take this to an estate planning attorney and say, here's what I'd like to have done.
And we can work with the estate planning attorney so that we can...
Sure, you coordinate it and do all that.
So oftentimes, we're all on the same page.
Yeah, oftentimes estate planning attorneys are not planning necessarily on the planning side. They're more on the executing side and making sure that this all gets done.
Right. And sometimes they'll make blanket statements, and they don't. This has not happened as much as it used to, but they used to just say, when they do a trust, change everything over to the trust. And so we would get requests to change the IRA ownership over to the trust, like while the person's still alive.
Yeah, okay.
We might not want to do that. Maybe he or she, the attorney, was just being a little bit broad in their instructions.
Yep.
You don't want to change the owner. You may or may not want to change the beneficiary to the trust. Let's talk about that.
Yeah, and that's exactly why a financial advisor, I think, should be in the discussion of an estate plan. Things like inheriting pre-tax accounts. You just don't want to give up that money to taxes if you can avoid it. 800-644-1150. Lucia Cap, LuciaCap.com is the website. You can also get in touch with any of the advisors or ask us a question right there. Don't forget to subscribe to our podcast, Managing Your Financial Future. Go to Spotify, do that, and get it downloaded right to your device, and never ever miss an episode, because you miss one, you miss a lot.
That's what it is.
That's what it is.
And everything builds on each other.
My thanks to Professor Rick Plum, certified financial planner professional. For him and for the rest of the gang at Lucia Capital Group, I'm your podcast host, Johnny Dean. Thanks so much for listening. Thanks so much for being a part of our podcast, and we'll talk to you again next time.
The information provided should not be considered specific tax, legal, or investment advice and is not specific to any individual's personal circumstances. To the extent that this material concerns tax matters, it is not intended or written to be used and cannot be used by a taxpayer for the purpose of avoiding penalties that may be imposed by law. Each taxpayer should seek independent advice from a tax professional based on his or her individual circumstances. Different types of investments and or investment strategies involve varying levels of risk, and there can be no assurance that any specific investment or investment strategy, including the investments purchased and or investment strategies devised by Lucia Capital Group, will be either suitable or profitable for a client's or prospective client's portfolio. Thus, investments may result in a loss of principal. Accordingly, no client or prospective client should assume that the presentation or any component thereof serves as the receipt of or a substitute for personalized advice from Lucia Capital Group or from any other investment professional. You should always seek counsel of the appropriate advisor prior to making any investment decision. All investments are subject to risk, including the loss of principal. This material was gathered from sources believed to be reliable. However, its accuracy cannot be guaranteed. Traditional IRA account owners have considerations to make before performing a Roth IRA conversion. conversion. These primarily include income tax consequences on the converted amount in the year of conversion, withdrawal limitations from a Roth IRA, and income limitations for future contributions to a Roth IRA. In addition, if you are required to take a required minimum distribution, or RMD, in the year you convert, you must do so before converting to a Roth IRA. IRA withdrawals will be taxed at ordinary income rates. Withdrawals prior to age 59.5 may also be subject to a 10% penalty tax. Roth IRA distributions of principal from a Roth IRA are tax-free. However, any earnings will be taxed at ordinary income rates, and a 10% penalty tax will apply if withdrawn prior to age 59.5 or within 5 years of the date the Roth IRA was established, whichever is longer. Annuities are long-term investment products designed for retirement purposes. Guarantees are based on the claims-paying ability of the issuer, subject to their terms and conditions. Early withdrawals may be subject to surrender penalties and, if taken prior to age 59.5, may be subject to an additional 10% federal tax. Annuities are not FDIC insured. Certain terms and conditions apply, so please read insurance company materials carefully. Examples cited are hypothetical, are for illustrative purposes only, are not guaranteed, and subject to potential federal and state law amendments. There is no guarantee that you will achieve the results discussed or illustrated. Insurance services offered through LPL Financial or its licensed affiliates. California Insurance License Number 0518721. The information provided is based on current laws, which are subject to change at any time. Lucia Capital Group is not affiliated with or endorsed by the Social Security Administration or any government agency. Social Security rules can be complex. For more information about Social Security benefits, visit the SSA website at ssa.gov or call 800-772-1213 to speak with an SSA representative. Rick Plum is a registered representative with and securities and advisory services offered through LPL Financial, a registered investment advisor, and member FINRA SIPC. The investment professionals are affiliated with LPL Financial and are conducting business using the name Lucia Capital Group, a separate entity from LPL Financial.